On December 10th, 2025, the courtroom of Judge Cedric Simpson in Michigan became the stage for a complex landlord-tenant dispute that would expose serious violations of Michigan's landlord-tenant laws. Plaintiff Lori Anderson, represented by attorney Edward Mall, filed two separate summary proceedings against her tenant, Ms. Lemon, seeking over $22,000 in unpaid rent and water bills. The defendant, Ms. Lemon, countered with claims of harassment and interference with her quiet enjoyment of the rental property. What began as a straightforward non-payment case quickly unraveled into a masterclass on how not to be a landlord, revealing commingled security deposits, fabricated ledgers, improper late fees, and potential harassment. Our footage begins in the middle of proceedings, with tensions already running high, and the judge about to uncover a pattern of landlord misconduct that would ultimately reduce the plaintiff's claim by over $10,000.
I apologize for that interruption.
Not a problem. Take your appearance, please.
Good morning, Edward Mall, MAHL P27115, attorney for the plaintiff.
All right, where are we on these cases?
Furnace had went out this morning. Not only did my furnace go out, Lori showed up to my house last month and had some guy walk around the back. But when he saw the camera, he ended up leaving. When the guy she had moved to the house saw the camera, he ended up leaving, and she's still sending falsified information about the case to the water.
To who?
The water department.
Okay. So somebody last week showed up to your house?
No, that's a video of him walking around the house.
Did you send somebody to the premises?
No, certainly did not.
She was in the car. You can see it in the
She
video.
was what?
She was in the car. You can see it in the video.
Ms. Anderson, you're indicating you didn't send anybody? So she had a video of that? That would.
I didn't send anybody to the house.
Were you at the house? Were you in a car near the house?
And about a month and a half ago, I think I drove by one time. I didn't drive to the house. I think I just.
Was the car sitting there, ma'am?
Yeah, the car was sitting out front.
No.
They pulled up a little bit.
Out front of
The house. They tried to get out the view of the camera, and then he proceeded to look at the camera, and then he walked around the house and he seen the camera, and then he went back to the car and they pulled up. So he didn't finish walking around the house because he seen the camera.
You have that video?
Yeah.
On your phone?
Yes.
Did you bring your phone in? Okay. Can you send it to the court if I gave you an email?
Ms. Lemon has just accused her landlord of sending someone to inspect her property without notice or permission, and claims to have video evidence showing Ms. Anderson in a vehicle while an unidentified man walked around the premises. Under Michigan's Truth in Renting Act, specifically MCL 554.139, landlords have a legal right to enter rental premises, but only under specific circumstances. The statute states that a landlord may enter the dwelling unit only for the following purposes: to inspect the premises, make necessary or agreed repairs, supply necessary or agreed services, or exhibit the dwelling unit to prospective or actual purchasers, mortgagees, tenants, workers, or contractors. However, and this is crucial, MCL 554.139(2) requires that the landlord provide reasonable notice and enter only at reasonable times. Michigan courts have interpreted reasonable notice to generally mean at least 24 hours advance written or verbal notice, except in emergency situations. In this case, Ms. Lemon is alleging that someone entered her property, or at minimum, walked around it, without any notice whatsoever. The presence of Ms. Anderson sitting in a vehicle suggests this was a coordinated inspection attempt. If proven, this would constitute a violation of the tenant's right to quiet enjoyment, which is an implied covenant in every residential lease in Michigan under common law principles established in cases like Adrian Development Co. versus Casco Services Corp. Even though a landlord owns the property, once they've leased it to a tenant, the tenant has possessory rights that must be respected. Unauthorized entry or inspection attempts can constitute unlawful interference with those rights. This violation isn't just a technicality. It goes to the heart of tenant rights and can form the basis for a counterclaim for harassment or interference with quiet enjoyment, potentially reducing or offsetting the landlord's claims.
These are all non-payment of rent cases, both of these.
There's a lot of issues, but we're slimming it down to non-payment of rent this morning.
Well, from plaintiff's position, What is plaintiff's claim in, I guess, either one of these cases?
Well, at this point, we are concentrating on rent. There's been only, how many months, 2 months paid? Only 2 months of rent paid.
So how much are you claiming is owed?
This includes water, because there's $1,900, more than $1,900 due for water bill for water that's left on. The balance is $15,899.39.
15,000.
$899. That gives her credit for the escrow, this with the court of $6,600. 2 payments of escrow have been made only.
She's claiming over 21,000 owed?
Yeah, she figures 22,400 is the balance. When I say she, I mean Miss Anderson.
And how much did you say?
66.
So let's take a look.
Yeah, I know that. I know that.
So what months is she claiming rent for?
All the months after, well, she has not paid anything since the first the 2 months, May and June. She owes the rent from
So
July.
you're claiming for July?
Yes, August, September, October, November, and December. Not include. Yes. Okay. Don't into the court.
Paid
I know,
what?
we know that.
Paid the
Where?
July and all that, I paid that.
Yeah, July and August have been paid. They're escrow. They're in escrow now. September, October, November, and December.
Just saying, counsel. So you're looking at 6 months, basically, right?
Yes, 6 months have not been paid to us. 2 months have been paid into the court. So this is 4 months owed.
3,300. So, Ms. Lyman, I'm a bit confused because when we appeared here before, you had indicated that you were going to pay the rent into court escrow, and I don't have anything. I only have 2 months in escrow. How much did you pay in escrow this morning?
I paid that $22.70 that I said I was going to pay.
$22.70.
Yes.
What's this? That's still, but that's not. Your monthly rent is 33.
Yes. Remember when I told you how I broke it down for the prorated amount? And that's what I came out to when we were here last time.
Okay, but if that paid, so here's my question. If I have in escrow July, we'll just call it July and August because those are the latest ones.
And I paid September this morning.
Okay, and then if that's, well, that's the 22.
Mm-hmm.
Yes, all right. So without going into even at this point, the difference between the two.
I'm only 2 months behind.
Okay, but where is the 2 months?
I don't have it right now. I was planning on paying at the end of the month.
I don't see how the 2270 pays at September either. And she's prorated it, but prorated, what does it mean? It's prorated. The entire amount is owed.
The judge is trying to determine exactly how much rent is owed, but encounters a major problem. Miss Lemon has prorated her rent payment in a way that doesn't match the actual rental period. She paid $2,270 instead of the full $3,300 monthly rent, claiming this was proper based on some calculation she made. Under Michigan law, specifically MCL 554.601 at SEC, the Truth in Renting Act, rental payments must be calculated according to the terms specified in the written lease agreement. Unless a lease specifically provides for prorated rent at the beginning or end of a tenancy, or when a tenant moves in or out mid-month, tenants cannot unilaterally decide to pay less than the agreed-upon monthly rent. The concept of proration is legally recognized, but only in specific circumstances. In the 1985 Michigan Court of Appeals case, Paragon Properties Co. v. Frost, the court held that proration is appropriate when a tenant occupies premises for only part of a rental period, but the calculation must be based on the actual days of occupancy divided by the total days in that rental period, multiplied by the monthly rent amount. Furthermore, MCL 554.134 requires that any modification to rental payment terms must be agreed upon in writing by both parties. A tenant cannot simply decide to alter the payment amount without landlord's consent. Here, Ms. Lemon appears to be attempting to create her own payment schedule based on a misunderstanding of proration. The judge quickly identifies that this is problematic. While Miss Lemon may believe she's entitled to credits for various reasons, we'll hear more about this, she cannot unilaterally reduce her rent payments below the lease amount without either a written agreement with the landlord or a court order establishing that she's entitled to a rent reduction or credit. The judge's questioning reveals that Miss Lemon is confusing several concepts. She mentions an overpayment in June and a security deposit issue, and appears to be trying to self-apply credits to current rent, a decision that's not hers to make unilaterally. This is a common mistake tenants make when they feel they're owed money by their landlord. Even if you have a legitimate claim for a refund or credit, you cannot simply deduct it from rent without permission. The proper procedure is to pay the full rent and pursue the credit through separate legal channels. Otherwise, you're technically in breach of the lease, giving the landlord grounds for eviction.
I don't know where this proration you have is coming from, where you're taking monies off for September.
Because in May, I didn't get prorated at all in May.
Pardon?
I didn't get prorated at all in May when I moved.
When you moved in?
Yes,
You moved in on what day?
on the 5th.
But your lease started what day?
Started on the 5th.
On the 5th, and runs through what?
The 5th of next September. I don't remember the date.
I have a copy of the lease, Your Honor. It starts May 5, 2025. It ends May 4, 2027
May 4th.
of 2020. I have a copy of the, you have got it, okay.
So you follow that, ma'am?
Yes.
So there would not be a proration because you would have 4 days essence at the end of your lease. If your lease ended on the 30th or 31st of a month, I could see and get your argument about the 5 days because you didn't live there those first 5 days. But the way your lease runs, it runs from the 5th, but ends on the 4th of whatever month. So you get all your time. It's just not on the calendar month, basically.
I would remind the defendant that she's ignoring the water bill that's $1,900.
Why are you dealing with that right now? Did I ask you about it?
I brought it up because she's not, just a reminder of it, yes.
Why?
She's not
I'm
talking.
trying to deal with something right now.
Okay, I'm sorry.
You follow that, Ms. Lemon?
Yes.
So give me a total of 66 plus 2270. 8,870. All right. Yes, ma'am.
I can pay the 533 today for the 5 days.
Say again.
The 533, I can pay that today for the 5 days.
So basically you can make September whole.
Yes.
All right. But what about the other 3 months and why aren't those paid into court escrow?
I got behind. A lot of family stuff had happened, so I had got behind. My plan was to pay those at the end of this month.
The judge has just delivered a crucial clarification about how lease periods work. Miss Lemon believed she was entitled to prorate her May rent because she moved in on the 5th of the month, assuming she shouldn't pay for the first 5 days. The judge corrected this misunderstanding by explaining the lease structure. This touches on a fundamental principle of contract law as it applies to residential leases. In Michigan, as in most states, a lease term doesn't have to align with calendar months. Under basic contract principles established in Restatement 2nd of Contracts, Section 201, the terms of a written agreement control the obligations of the parties. When a lease runs from the 5th of one month to the 4th of another month, the tenant is paying for a full month's occupancy, just not a calendar month. The first payment covers May 5th through June 4th. The second payment covers June 5th through July 4th, and so on. Michigan's Truth in Renting Act, MCL 554.634-2, requires that lease agreements specify the rental payment terms, but does not mandate that rental periods align with calendar months. Courts in Michigan have consistently held that parties are free to structure their rental periods however they choose, as long as the terms are clearly stated in the lease. In this case, Miss Lemon made a common mistake. She saw that she moved in on the 5th and thought, I'm only here for 26 days this month, so I should only pay 26/31 of the rent. But her lease doesn't work that way. She's paying from May 5th to June 4th, a full 31 days of occupancy. At the end of her lease, she'll have those extra 5 days at the beginning built in. She'll leave on May 4th, not May 31st. This is why it's critical to read your lease carefully. The judge rightfully notes that if the lease had ended on a month-end date, Ms. Lemon would have a valid argument for proration at the beginning. But with this lease structure, she receives a full rental period from day one. This type of misunderstanding can lead tenants to underpay rent, putting themselves in breach of the lease and facing eviction, all based on a misreading of their rental agreement. The lesson? Your rental period is what your lease says it is, not what the calendar says it is.
No, because I was talking about the extra 200 that I paid in June and plus the 300 I was supposed to be getting back. That 532. The $300 on the deposit.
For what?
The overpayment in June, I paid $200 in June, and then the $300 from deposit that I was supposed to get back.
The 300 from the cleaning deposit?
It was for
The what?
moving in.
Your Honor, if I could explain, there's a security deposit. It was determined by the plaintiff that the security deposit was $300 too much based on the guidelines in this state of Michigan statutes. So she gave her a $300 credit, and it's shown on this ledger.
For June.
But shown on the ledger for the total balance. It's from the balance. The balance, it's part of the number that
But
is
what
taken
month
into
did she
account.
get the credit for? Because
It's not for a particular month. It's just on account. She's saying it's for a particular month. We're saying it's on account.
well, it's got to be for a particular month. When was the security paid?
May security, it was paid in May.
So if she overpaid the security, that means it's credited toward May rent. Gotta be.
All right, then we have credited it to her on the account, whether it's whatever month it's applied for. She's gotten that credit. It's shown on this ledger.
When did I get the credit? Because nobody told me. He just told that she was supposed to give me the $300 back.
Say.
In June, I overpaid $200 as well.
I get what you're saying, that there was an overpayment in June, but how much did she pay in June?
She paid $3,300 in June.
3,300?
The rent, she paid her late fee for June.
Oh, late fee.
How much is the late fee?
The time she paid.
How much is the late fee?
The late fee is $150, but I think she may have paid $250. I don't have those records with me. She just put it in my account automatically.
Council has a ledger sheet in front of you. Does that ledger sheet reflect that overpay?
It doesn't. It reflects a charge of $150 for.
But she says she paid 200 and something.
Yeah.
Oh.
She directly deposited the funds into my checking account. She didn't give me a pin. She put an extra $250 in the account for June. She directly deposited.
Okay, I don't care how it got there. Is the ledger sheet that council has, does it reflect that that payment was made?
No, because the letter sheet is just from July forward.
Why isn't there a ledger back to the beginning of her tenancy? Or if it's just from July forward, why doesn't it reflect, does it give a credit at the beginning?
We've just witnessed a critical failure in the landlord's record keeping. Ms. Anderson provided a ledger that only starts from July, omitting the first 2 months of tenancy where there were payments, overpayments, and credits. The judge is rightfully frustrated because it's impossible to verify who owes what without a complete accounting. This brings us to one of Michigan's most important landlord-tenant laws, MCL 554.608, which governs security deposit accounting. This statute requires that within 30 days after a tenant takes possession, the landlord must provide written notice stating the landlord's name and address and the financial institution and account number where the deposit is being held. More importantly, MCL 554.603 limits security deposits to 1.5 months rent. In this case, with rent at $3,300 per month, the maximum legal security deposit would be $4,950. If Ms. Anderson collected more than this amount, she was required by law to refund the excess, which explains the $300 overpayment. But here's where it gets serious. MCL 554.608 sub 3 states that if a landlord fails to comply with these requirements, the tenant may recover the full deposit. Furthermore, Michigan courts have held in cases like Kiever v. Muma that landlords have an affirmative duty to maintain accurate records of all rental transactions, including payments, credits, and charges. Ms. Anderson appears to have violated multiple provisions of Michigan's security deposit law. She collected more than the legal limit, requiring a refund. She failed to maintain a complete ledger from the beginning of tenancy. And as we'll soon hear, she failed to properly segregate the security deposit. The judge's repeated question, why isn't there a ledger back to the beginning of her tenancy, is not just about organization, it's about legal compliance. Without proper records, how can anyone verify what was paid and when, what credits were applied, whether late fees were properly charged, whether the security deposit was properly handled? The attorney's answer, that the ledger only starts from July because that's when rent stopped being paid, reveals a fundamental misunderstanding. You don't start keeping records when there's a problem. You keep records from day one. That's not just good business practice. In Michigan, it's the law. Improper record keeping can sink a landlord's case. Even if the tenant genuinely owes money, if the landlord can't prove it with accurate records, the court may rule against them. Additionally, violations of Michigan security deposit laws can result in the landlord forfeiting their entire claim to the deposit, plus potential penalties.
He's entitled to a credit of $100 for June.
How do I get $100 when that's not what Ms. Anderson just said?
She paid $250 for a late charge. Is that what?
She should have
Okay.
just paid
She should have paid $150. So
She didn't give.
Okay, does the ledger that I have, that you have, counsel, does it reflect that credit?
no,
Why not?
my client compiled this from the date at which the date at which the rent was not paid. So
There isn't a concurrent ledger that's kept?
Well, last time we were
Something
here,
that was made up afterwards?
go ahead and explain when you prepared this one.
I prepared this ledger for, I didn't know I was supposed to prepare it for the previous month. I just prepared it for July.
Why doesn't her account have a ledger? Why isn't there a ledger that reflects payments on this tenancy? What was the answer to that?
I just didn't prepare a ledger before. I didn't know I was supposed to prepare a ledger before the court escrow.
So how do I find out what she paid in May? How do I find out what she paid in May? But where is that coming from? I don't,
Your bank account shows the payments that you received.
Yes, my bank account shows it.
so, and so if that ledger starts out in July, this one that's been created, it doesn't show a credit.
For the $300 overpayment for the
June.
security deposit and the $100 overpayment for the, so we need.
But you're-
So I guess what I'm saying is, why come July, if that ledger's to be believed, do I not have a $400 credit, which means that for July, she should have only paid $2,900?
We have a $300 credit on the ledger. We just are missing the $100 credit.
Oh, this
So we're missing the $100.
No. You have it at some point on that ledger, right? But if you created a ledger that accurately reflects this tenancy, that means her opening balance that she would have owed as of July 1 would have been $2,900.
The judge has identified another serious problem. The landlord charged late fees even when the tenant was paying rent into court escrow as ordered. This is improper under Michigan law. When a judge orders rent to be paid into escrow during pending litigation, this fundamentally changes the landlord's remedies. Under Michigan court rules, specifically MCR 4.201C, when a tenant is ordered to pay rent into court during a summary proceeding, the tenant is fulfilling their rental obligation by making those escrow payments, even if they're late to the courthouse. The key case on this issue is Sunrise Retirement Villa versus Anderson, where the Michigan Court of Appeals held that once rent is being paid into court escrow pursuant to a court order, the landlord cannot unilaterally impose additional charges like late fees. The court's reasoning was clear. The escrow system is designed to protect both parties during litigation, and the tenant is complying with a court order by making escrow payments. If a tenant pays escrow late, the landlord's remedy is not to charge late fees. It's to request that the court enforce its escrow order or proceed to trial immediately. MCR 4.201D specifically provides that if escrow payments aren't made timely, the court may proceed with an immediate hearing on the merits. Ms. Anderson made a critical error here. She saw that Ms. Lemon paid her escrow installments late to the court and thought, great, I can charge late fees. Attorney Mall even stated explicitly that late fees were justified because Ms. Lemon paid the rent late to the court. But that's not how court-ordered escrow works. The proper procedure would have been, if Ms. Lemon didn't pay escrow on time, notify the court. Request that the court enforce its order. Ask for an expedited trial date. Potentially seek judgment if Ms. Lemon failed to comply with the court's escrow order. What Ms. Anderson could not do is unilaterally add $150 per month in late fees, $900 total, to someone who was complying, even if slowly, with a court order. This is a $900 mistake that directly reduced Ms. Anderson's recovery. The judge will ultimately disallow $300 of the $900 in claimed late fees, finding them improper. This illustrates why landlords need to understand court procedures, not just lease terms. When a case is in litigation and the court has issued orders, those orders supersede normal lease provisions. You can't just keep running the late fee meter when rent is being paid into escrow.
How much did she pay in security deposit? And where is that being held?
In my bank.
In what?
In my bank.
Is it in a separate account?
Yeah. Can I explain something?
No, answer my question.
Yeah. Yes. Yes.
Where's it being held was the question.
Chase Bank.
In a separate account.
Since then I've moved.
Is it in a separate account? Has it been in a separate account from the beginning?
No, because I actually moved everything over to LMC.
So I don't know where her security deposit is.
You said it's a Chase or it's been moved to?
I actually closed the Chase account down, and it's my LMC account.
What is LMC?
It's a like Michigan credit. It's just I was getting charged too much.
Okay, just tell it, Judge, where it is. What bank is it?
LMC.
What is LMC?
It's like Michigan.
Did you notify the tenant that that's where the security is being held?
No, because I also.
Is it in a separate account at this new institution? It's just commingled with your account?
It's actually the savings account, so it's.
Is it commingled with your savings account?
No, I have a separate savings account and I have a separate checking account.
Try the question again. Is it in a separate account that delineates it as a security? So it's in your savings or checking account?
Yes.
It's commingled with your funds?
Yeah, but I don't.
It's commingled with your funds.
Yes.
The judge has just uncovered a serious violation. Miss Anderson has been keeping Miss Lemon's security deposit in her personal savings account, mixed with her own money, and she never notified Miss Lemon that she moved the deposit from Chase Bank to Lake Michigan Credit Union. This violates multiple provisions of Michigan's Security Deposit Statute, MCL 554.608. Let me read you the exact requirements. Section 554.6081 states, a security deposit shall be deposited in a regulated financial institution, and the landlord shall not commingle the deposits with their personal assets. Section 554.6082 requires, within 30 days after receiving a security deposit, the landlord shall notify the tenant in writing of the financial institution and address where the deposit will be held and the account number. Section 554.6084 adds, if the landlord transfers the deposit to a different account or institution, the landlord shall notify the tenant of the transfer, the new institution, and new account number within 30 days. The Michigan Court of Appeals addressed this exact issue in the 1996 case Eden v. Genesee Meadows. holding that commingling security deposits with personal funds is a per se violation of the statute, meaning it's automatically unlawful, regardless of the landlord's intent or whether any harm resulted. Let's count Miss Anderson's violations. Commingling. She kept Miss Lemon's security deposit in her personal savings account. This is illegal, period. The law requires a separate account specifically designated for security deposits. Failure to notify of initial location. While Miss Anderson may have initially notified Miss Lemon that the deposit was at Chase Bank, she never provided the account number as required by law. Failure to notify of transfer. When she moved the deposit from Chase to LMCU, she was legally required to notify Miss Lemon within 30 days. She never did. Miss Lemon testified she had no idea where her security deposit was being held. No segregated account. At LMCU, instead of opening a new trust account or landlord security deposit account, she just dumped the money into her existing personal savings account. Why is this such a big deal? Because security deposits are the tenant's money, not the landlord's. The landlord is holding it in trust. If the landlord goes bankrupt, gets sued, or has their account garnished, the tenant's deposit could disappear. That's why the law requires complete segregation from the landlord's personal assets. Under MCL 554.608.7, a tenant can recover their full security deposit plus damages if the landlord violates these requirements. In some cases, Michigan courts have awarded tenants double their deposit as a penalty for landlord violations. Here, the judge will ultimately factor this violation into the final judgment, and it significantly undermines Miss Anderson's credibility throughout the case.
And how much is the plaintiff claiming in additional water?
The water bill is 19. This is just for May 5th to December 8th. Is 1915.80.
1915?
Yep, 80.
80?
Yep.
And the water bill, I had a payment plan. I had a plan figured out. And when I called, they said she called and took the water out my name, put it in hers, and paid it. And then I sent the
Did
email
you
about
do that?
What happened was.
No.
Yes,
Did you do
yes,
that?
because he said it would go to my tax bill. She didn't accept the plan by that date, the 13th of October, which she did not. I have the manager of the utility company said she did not do that. And so I came in personally and set it up and paid it with borrowed funds so that it wouldn't go.
I don't care where the funds came from. You paid it.
Yes, so it wouldn't go on my tax bill because that's what they do. They don't.
I understand what they do. I didn't ask all that.
I just was protecting myself.
So the water bill's been paid.
Yes, sir.
Do I have a receipt for the amount paid on the water bill?
Yes, sir.
when I talked to Landon.
There's been 3 bills.
We have one bill here.
We submitted everything to what?
Oh, well, we don't have it right now. It's one bill.
1315.83.
Yes.
We'll just show that, Simon.
Okay. All right, it's okay. Okay.
All right. Ms. Lyman, you saw that water bill?
Yes,
Okay. And that was the amount you were going to set up a payment plan?
yes, that's when I called to set up, they said like an hour and a half or an hour. She had called in, took the bill out of my name and put it in hers and paid it in full. And then when I emailed about it, she had said, oh, well, you can just pay me now.
Okay, but you're not disputing that that's a water bill you would have had to pay.
Yeah, that's what I would have to pay.
You would have had to pay that 13. Yeah, you would have had to pay it anyway. You were just going to do it a different way with the township.
Yes,
Okay, all right. So you're not disputing the figure.
no, that's the amount that I got billed for. I had a payment plan worked out where I was just going to pay it over time, not all in full at once.
Miss Anderson took over the water bill by transferring it from Miss Lemon's name into her own name and paid it in full, claiming she needed to do this to prevent the bill from going onto her property tax assessment. Miss Lemon had arranged the payment plan with the water utility, but never got the chance to use it. This situation involves the intersection of lease obligations and utility company policies. Under Michigan law, the question of who pays utilities is governed by the lease agreement. If the lease specifies that the tenant is responsible for water, then the tenant must ensure it's paid. However, Michigan municipalities have a special power under MCL 123.161, which allows them to place unpaid water bills as a lien on the property and add them to the property tax bill if they remain unpaid for a certain period, typically 6 months to a year depending on the municipality. Here's where it gets interesting. Under Lakeland Property Owners Association versus Township of Northville, Michigan courts have held that property owners, landlords, have standing to pay tenant-responsible utilities to prevent liens on their property. However, just because you can do something doesn't mean you should, at least not in the way Ms. Anderson did it. The lease agreement here clearly made Ms. Lemon responsible for water. MCL 554.139 would allow a landlord to take action to prevent property damage or maintain essential services. But paying a water bill that wasn't yet on the tax roll doesn't quite fit that definition. Let's analyze what Ms. Anderson should have done versus what she did. What she should have done: review the lease to confirm water was tenant's responsibility, send written notice to Ms. Lemon that the water bill was overdue and would become the landlord's problem if not addressed, provide a reasonable deadline for payment, at least 7 days. If Ms. Lemon didn't pay, then pay it and add it to rent owed or file for summary proceedings. What she actually did, apparently without notice to Ms. Lemon, called the water department, had the account transferred to her name, paid it in full, prevented Ms. Lemon from using her payment plan. The judge's question cuts to the heart of the matter. Why did you take it out of her name? If Ms. Anderson's goal was simply to ensure the bill got paid, she could have paid it while keeping it in Ms. Lemon's name. The water company doesn't care whose name is on the account as long as they get their money. By transferring the account to her own name, Ms. Anderson deprived Ms. Lemon of the opportunity to maintain her payment plan, which is what the judge will ultimately identify as harassment, interfering with the tenant's reasonable attempts to handle her obligations. Courts look at patterns of behavior. One incident might be oversight. Multiple incidents start to look like harassment. When combined with the security deposit violations, the improper property visits, and the late fees charged during escrow, this water bill incident becomes additional evidence of a landlord who wants excessive control over her tenant, control that exceeds what the law allows. The judge will factor this into his final ruling, using it as part of the basis for awarding Ms. Lemon damages on her counterclaim for interference with quiet enjoyment.
Where's the email that says that it was going to go to your taxes if it wasn't paid or an arrangement not made?
I can get an email from the town.
You said there was one.
I have an email from the gentleman. I emailed it to the court. I CC'd the court. It's in the court record.
It doesn't immediately go on your taxes in any event.
They said
it doesn't immediately go on your taxes. I know how it works. So why did you take it out of her name?
This is from Cindy Roberts.
Why did you take it out of her name? But you could have paid it and it stayed in her name. Why did you take it out of her name? That isn't an answer to my question. On the day you went in to pay it, you're telling me that you paid it because you were worried that it was going to go on your taxes. Okay, that's fine. It doesn't quite work that way, but that's fine. But then the question becomes, why did you take the water bill out of her name?
Because I wanted to be responsible, so I wouldn't be behind.
But that's not what the lease says, does it?
It says it could be, the lease says it could be paid by me and she reimbursed me, So I was just gonna give her a benefit.
Why was it put in her name in the first place?
I was giving her the option of being able.
Why was it put in her name in the first place?
They told me at the township that it could be put in her name if I wanted it.
Okay, so then it's put into her name. So then it comes down to this date. Why do you change the name on it?
13th, they said if the water bill was due, it wasn't paid. I came at like 2 o'clock and they closed it.
Why did you change the name?
Because I wanted to be responsible for paying the water. I didn't want it to get behind again.
And so you couldn't be responsible without changing the name?
I could put it back in her name.
That's not what I said. You're telling me that you had to change the name so that you could be responsible for it.
So they could send me the bills and I can keep up with it and pay the water.
They would send you the bill anyway. You could always go online. You can look it up.
I just was concerned. That's all, sir.
But why was it important for you to change the name?
I thought I needed to be responsible for it. That's all. I just wanted to make sure I got the bill.
You're the homeowner.
Well, maybe I didn't know. I just did the best I could.
No, you did that to harass her.
The judge has just cut through Miss Anderson's evasive answers and made a direct finding. No, you did that to harass her. This is a pivotal moment where the judge is no longer asking questions. He's making factual findings about Miss Anderson's intent. Intent is crucial in harassment cases. Under Michigan law, harassment doesn't require that the landlord subjectively intended to cause distress. It's evaluated objectively based on whether the conduct would cause a reasonable person to feel harassed. However, when a court can find actual intent to harass, it strengthens the harassment claim significantly. In Grosse Pointe Park versus Michigan Municipal Liability, the Michigan Court of Appeals established that when evaluating harassment claims, courts should examine whether the defendant had a legitimate reason for their actions, whether less intrusive alternatives were available, whether the defendant's stated reasons are pretextual, the pattern of conduct taken as a whole. The judge's repeated question, "Why did you change the name?" is applying this test. He's giving Miss Anderson multiple opportunities to provide a legitimate explanation. When she can't, and when he recognizes that she could have paid the bill without changing the account name, he concludes the action was pretextual. Let's break down the judge's analysis. Question 1. Was there a legitimate reason? Miss Anderson claims she needed to protect herself from a tax lien. The judge acknowledges this could be legitimate, but notes it doesn't quite work that way. Water bills don't immediately go to tax rolls, and there's typically a lengthy process before that happens. Question 2. Were less intrusive alternatives available? Yes. The judge identifies the key point. You could have paid it and stayed in her name. The water department doesn't care whose name is on the account as long as the bill gets paid. Miss Anderson could have paid the bill online in Miss Lemon's name, gone to the water department and made a payment towards Miss Lemon's account, sent a check with Miss Lemon's account number. None of these required transferring the account to her name. Question 3. Were the stated reasons pretextual? Miss Anderson kept saying, "I wanted to be responsible and I didn't want to get behind." But the judge recognizes these don't answer the question. Being responsible for payment doesn't require changing the account name. The judge concludes these are excuses, not reasons. Question 4. Pattern of conduct? Combined with unauthorized property visits, sending unknown persons to photograph the property, improper late fees, security deposit violations, filing 2 lawsuits, accusations of fraud. The water bill incident becomes part of a clear pattern of excessive control and harassment. The judge's direct statement, "No, you did that to harass her," is a factual finding that will be recorded in the official court record. This isn't speculation or hypothesis. It's a judicial determination based on evidence. This finding is particularly powerful because it comes after the judge gave Miss Anderson multiple chances to explain herself. He asked the same question several different ways, clearly hoping she'd provide a reasonable explanation. When she couldn't, and when he recognizes that she could have paid the bill without changing the account name, he concludes the action was pretextual. For tenants facing similar situations, document everything. Miss Lemon's testimony about having a payment plan arranged, combined with the timing of Miss Anderson's action, apparently within hours of Miss Lemon setting up the plan, provided the judge with clear evidence of interference. For landlords, this illustrates why you should always ask yourself, is there a less invasive way to accomplish this? If the answer is yes, and you choose the more invasive option anyway, a court may find harassment.
Because you could have paid that bill. At any given point, you can go right online and pay that bill. They don't care who's it's coming from. If that money is there, it's there.
He says that I could pay water and she would reimburse me. I was just giving her an opportunity to put it in her name.
It was already in her name.
Not from the very beginning, it was in my name.
Was it in her name?
Not in May when she moved in. I put it in her.
That was the first month.
I let her.
In June, was it in her name? July,
No,
August,
I let her put it in August.
September, October.
According to recollection, I think I took it out of her name in October, so I think I had it in her name 2 months.
Oh, dear goodness, why? Why'd you do that?
I just wanted to,
That was a question.
I was just trying to get it paid, so, all right.
You would agree with me, Miss Anderson, that you could pay that bill without changing the name. You know, at the time you paid it, you didn't need to change the name, didn't you? No, that's not what you knew at the time, that you didn't have to change the name.
You know, did you not know that?
I didn't.
She said you didn't know that.
All right. Counselor, you gave me a number at the very beginning of 22,49939, which has been changed to 22,39939
Yes,
as the total rent.
yes. Not counting escrow.
Right, not counting the escrow.
Right.
When you gave me 33 times 6, you gave me 1,900. So just so that I'm not double counting, I get for the 6 months of rent, I get 19,800.
19,800. Yeah, that's what,
that's what I get for the 6
You don't have to
months.
point that out to me. I understand that. 19,800. That's correct for 6 months.
Okay, so what's our difference? When you gave me the 22, now 399, you gave me 22, basically 499. And then, but when I count the 6 months, I get 19,008. So I don't.
Okay. Well, we also get 19,800 for 6 months, but we add to it the water bill of 1950.
Gotcha. Okay.
And we get the court costs of 183.50. And we get late fees of $900.
Late fees of 900.
Yes, they're 150 per month.
Were late fees subtracted out for the payments made into court escrow?
She was late every time it was paid.
Why can't I just get an answer to my question?
No, they were not taken into account in the money she paid into the escrow. She paid $3,300 twice.
The judge is now carefully reconstructing the financial accounting, and he's catching another problem. Miss Anderson charged $900 in late fees, $150 per month for 6 months, without accounting for the fact that 2 of those months were paid into court escrow, where late fees shouldn't apply. We've already discussed MCR 4.201 regarding court-ordered escrow, but this exchange reveals another important principle. The burden of proof in civil cases rests with the plaintiff. Under Michigan Court Rules 2.116 and the general principles established in Clark v. Dahlman, the party making a claim must prove each element with admissible evidence. When a landlord claims late fees, they must prove the lease authorizes late fees, the rent was actually paid late, the amount of the late fee is reasonable and complies with Michigan law, any applicable exceptions don't apply, like court-ordered escrow. MCL 554.634 Quantity 1 requires that late fees be reasonable and typically interpreted by Michigan courts as no more than 5% of the monthly rent. Here, $150 on $3,300 rent equals 4.5%, so it's within the legal limit, if properly charged. Notice the judge's frustration. Why can't I just get an answer to my question? This is now the pattern throughout this case. Attorney Mall, and by extension Miss Anderson, keep trying to justify charges without directly answering what the judge asked. The judge asked a specific question: were late fees subtracted out for the payments made into court escrow? The answer should have been, no, Your Honor, the $900 includes late fees for all 6 months, including the 2 months paid into escrow. Instead, Attorney Mall said she was late every time it was paid. That's not an answer to the question. It's an attempt to justify the late fees without admitting they were improperly charged for escrow months. The judge's calculation reveals the problem. Total months owing, 6, July through December. Months paid into escrow, 2, July and August, based on earlier testimony. Months that should have late fees, 4, September through December. Late fees claimed, 6 months times $150 equals $900. Late fees that should have been claimed, 4 months times $150 equals $600. Improper overcharge, $300. This is exactly what the judge will deduct in his final ruling. This illustrates a critical point about civil litigation. You can't just throw numbers at a judge and hope they stick. Judges, especially experienced ones like this, will do the math themselves. When they find errors, especially errors that consistently favor the party making the claim, it damages credibility. Attorney Mall is trying to advocate for his client, but he's put in an impossible position. Miss Anderson apparently provided him with a total figure, $22,399.39, that included improper late fees. Now, under oath and under questioning, the truth is coming out. For attorneys, this is a reminder. Verify your client's numbers before filing. Don't just take their word for what's owed. Examine the ledgers, check the calculations, and ensure everything complies with applicable law. For landlords, accurate accounting isn't optional. When you go to court, a judge will scrutinize every dollar you claim. If your numbers don't add up, you'll lose credibility and money.
Ms. Lyman is claiming, before I go back and look at this tape, did you send a gentleman to the premises? Make sure you give me a correct answer.
That was your question? Okay.
Did I send a gentleman to the house? No. She said I was in the car.
You have also, to this court, indicated you were not in the car in front of the house. Is that correct?
Sitting in the car in front of the house? No, I drove by one time. Just to check on the house. I've driven by one time in 4 months. 4 months I've driven by one time.
He's not asking about that.
No, I was not in front of the house waiting for anything.
Do you know anything about the gentleman that came to the house and came around the back of the premises, as Ms. Lyman has indicated?
No.
Ms. Lyman, just to be clear, what date was that? November 10th.
At like 9 in the morning.
The judge is now confronting Miss Anderson about the video evidence before he goes back to review it during a recess. He's giving her one more chance to explain the unknown man who appeared on Miss Lemon's property, and she's denying any knowledge of it. This exchange implicates several legal principles related to witness credibility and perjury. Under Michigan law, MCL 750.422 makes perjury a felony punishable by up to 15 years in prison. Perjury occurs when a person knowingly makes a false statement under oath in an official proceeding. However, courts recognize that not every false statement is perjury. The person must have knowingly lied about a material fact. In People v. Reese, the Michigan Court of Appeals held that for perjury to occur, the statement must be made under oath. The statement must be false. The person making it must know it's false. The statement must be material to the proceeding. More relevant to this civil case is the issue of witness credibility. Under Michigan Rules of Evidence 607, a witness's credibility can be attacked by showing prior inconsistent statements, bias or interest in the outcome, character for untruthfulness, inability to perceive or remember events accurately. When a judge finds that a witness has lied or been evasive, it affects their credibility on all other testimony. This is based on the legal doctrine of falsus in uno, falsus in omnibus. False in one thing, false in everything. Look at the careful way the judge is questioning Miss Anderson. Make sure you give me a correct answer. This is a judicial warning. The judge is essentially saying, I'm about to look at video evidence, so don't lie to me right now. Did you send a gentleman to the premises? Direct question requiring a yes or no answer. Miss Anderson answers no. Were you not in the car in front of the house? Another direct question. Miss Anderson starts to deflect, I drove by one time in 4 months, until her own attorney cuts her off. He was not asking about that. Do you know anything about the gentleman? Final chance to explain. Miss Anderson, no. Now the judge has Miss Anderson on record under oath denying knowledge of sending anyone to the property, being in a car near the property beyond one drive-by, knowing anything about the man in the video. The judge then asked Miss Lemon for the specific date, November 10th. He's creating a clear record before he reviews the video evidence during the recess. If the video shows Miss Anderson in a vehicle while this man is on the property, her testimony here becomes a credibility problem. Even if she technically didn't send him, maybe he volunteered, or maybe she just told him about her concerns and he took it upon himself, her evasive answers and denials will look like dishonesty. This moment demonstrates the importance of truthful testimony. Miss Anderson is in a tough spot. Admitting she sent someone to the property would be admitting to potential harassment and trespass. But denying it when video evidence exists creates a worse problem. Now she looks like a liar. The better approach would have been, "Your Honor, I was concerned about property damage based on specific concern. I asked name, who is relation, contractor, friend, etc., to drive by and take exterior photos to help me assess whether I needed to request a formal inspection. I now understand this was improper without notice to Miss Lemon, and I apologize." That answer admits the conduct, can't be caught in a lie, provides context, not random harassment, shows remorse, mitigates damages, avoids perjury risk, tells the truth. Instead, Miss Anderson chose to deny everything, and the judge is about to watch video that may contradict her testimony. This is why credibility matters. Once a judge catches you in one lie, they question everything else you've said.
And what's your argument in terms of the interference with her possessory interest?
There's been no facts presented other than this person who walked to the back of their house about interference with her possessory interests.
Okay, so that I hear you, counsel, but can I just say that, and again, you weren't here when that other case, and when I was coming back to give my decision, actually, she's put forth other claims of where your client has gone to the house. This one that she put forth today is one that wasn't included in that.
Well, I know that you were not again. What the heck? I'm sorry.
The only time I was at the house was when he was court ordered. I haven't been at the house since. I don't go to the house.
Oh, okay, all right. There was a court. I know that there was a court-ordered inspection of the
Yes,
house, and she was
because there had been problems with coming to the premises and then claims that she wasn't able to get in.
right. You were here. You were there at the inspection, right?
Yes.
Okay, she was there at the inspection.
Correct.
Me and I were there.
Okay.
But I haven't been back
You've not been there other than.
other than driving by.
Oh, you already talked about driving by.
Yeah, just to make sure the house is.
There was not. You've not been on the premises
No,
except for
Have
that
you
inspection.
sent others on the premises?
No.
You've not authorized anybody to be on the premises, Ms. Anderson?
I don't even know if it's still there. I drive by every now and again, make sure it's still there. I don't.
Okay, you already said that. Okay.
Attorney Mall is trying to argue that there's insufficient evidence of possessory interference, but the judge cuts him off. He has context that the attorney doesn't have from previous hearings. The judge also catches Ms. Anderson contradicting herself again about property visits. This exchange highlights an important aspect of civil procedure, the cumulative nature of evidence across multiple hearings. Under Michigan Court Rules 2.507, when a case has multiple hearings or is continued over time, the court may consider all evidence presented throughout the proceedings, not just what's offered in a single hearing. In Smith v. Smith, a Michigan Court of Appeals case, the court held that trial judges have broad discretion to evaluate witness credibility based on their demeanor, consistency across multiple appearances, and the overall pattern of testimony. Attorney Mall is at a disadvantage here. He apparently wasn't present for earlier hearings where Ms. Lemon presented evidence of other unauthorized property visits. The judge has that full picture, which Attorney Mall doesn't. This also relates to the doctrine of judicial notice under MRE 201. A judge can take judicial notice of facts from other proceedings in the same case, including testimony and evidence from earlier hearings. Let's analyze what just happened. Attorney Mall's position. There's been no facts presented other than this person who walked to the back of the house. The judge's response. Actually, she's put forth other claims of where your client has gone to the house. This one that you put forth today is one that wasn't included in that. This reveals that there were previous allegations of property visits. Today's video evidence, November 10th, is new and additional. The judge has a more complete picture than the attorney. Attorney Mall then tries to rehabilitate his client by noting there was a court-ordered inspection where Ms. Anderson had every right to be present. But this actually backfires because it highlights that when Ms. Anderson had legitimate court-approved access, she used it properly. So why the unauthorized visits? Then Ms. Anderson keeps adding to her testimony. I drive by every now and again, make sure it's still there. The judge's response, okay, you already said that, is a subtle rebuke. She's being repetitive and defensive, which makes her look evasive. For attorneys, always be fully briefed on the case history before hearing. Attorney Mall was disadvantaged because he apparently didn't know about previous incidents, which made his argument that there's insufficient evidence of harassment fall flat. For parties, stop talking when you've answered the question. Ms. Anderson kept adding explanations and justifications that weren't asked for. This pattern of over-explaining often signals dishonesty or defensiveness to judges. For tenants, document everything and present it to the court. Ms. Lemon apparently presented evidence of multiple incidents over time, which created a pattern that the judge could recognize as harassment rather than isolated incidents. The judge's statement that this November 10th incident wasn't included in the previous evidence, is actually helpful to Ms. Lemon. It shows the harassment is ongoing and escalating, not a one-time misunderstanding.
I'm going to say, counsel, that, and again, you're at a slight disadvantage that doesn't quite fit with what's been presented to the court previously. So, all right. You sent that video?
Yes.
All right. So Ann has it. All right. So what I'm going to do is I'm going to stand in recess.
The judge is calling a recess so he can review the video evidence Ms. Lemon submitted. He's also ensuring that Attorney Mall receives a copy so he can review it as well and prepare a response. This procedural step is governed by Michigan Rules of Evidence 1006 and Michigan Court Rules regarding the admission of video evidence. Under MRE 901, video evidence must be authenticated, meaning someone must testify that it accurately represents what it purports to show. Additionally, MRE 403 requires that the probative value of evidence must outweigh any prejudicial effect. Video evidence is generally highly probative because it shows exactly what happened, but courts must ensure it's authentic and hasn't been edited or manipulated. The judge's decision to review the video during a recess rather than watching it in open court is within his discretion under MCR 2.513. This allows him to carefully examine the evidence without the time pressure of having all parties waiting in the courtroom. His decision to ensure Attorney Mall receives a copy implements the principle of procedural fairness. Both sides must have access to the evidence being considered. The judge's comment to Attorney Mall, "You're at a slight disadvantage," is a recognition that Attorney Mall may not have full knowledge of the case history. By giving him time to review the video during the recess, the judge is ensuring procedural fairness. This also shows good judicial practice. Authenticate the evidence. Ms. Lemon testified the video is from her security camera. Give notice to opposing counsel. Ensure Attorney Mall gets a copy. Review carefully. Take time to examine the video thoroughly. Allow response. Give Attorney Mall opportunity to review and respond. The light moment about spam calls shows the judge trying to ease tension in what has been a contentious hearing. But make no mistake, the substance is serious. The judge is about to review video evidence that could prove Ms. Anderson lied under oath about knowing nothing about the man on the property. Video evidence can be case-changing in landlord-tenant disputes. Security cameras are increasingly common, and tenants who feel harassed should absolutely document unauthorized visits. However, video evidence must be preserved properly. Don't edit or alter it. Preserve the original files with metadata. Be able to testify about when and how it was recorded. Provide clear copies to the court and opposing counsel. Ms. Lemon did this correctly. She has the video on her phone, she can send it via email, and she can testify to what it shows and when it was recorded. For landlords, assume you're being recorded. If you go to a landlord property or send someone else there, document your legal right to be there, provide proper notice, and conduct yourself appropriately. Otherwise, video evidence of your unauthorized visit could cost you thousands of dollars in a harassment counterclaim. After reviewing the video evidence during the recess, the judge reconvenes court to render his final decision. What he's seen on that video, combined with all the evidence presented throughout these proceedings, will inform one of the most detailed and damning rulings against the landlord's conduct that this court has issued. The cumulative effect of Miss Anderson's violations, the commingled security deposit, the fabricated ledger, the improper late fees, the water bill interference, the filing of 2 lawsuits, and now the video evidence of unauthorized property visits has painted a clear picture for the judge. As we transition to the judge's final ruling, remember that we're watching more than just a rent collection case. We're watching a masterclass in how not to be a landlord and how a judge will use his equitable powers to protect tenant rights even when the tenant owes substantial back rent. The question now isn't just how much does Miss Lemon owe, it's how much will Miss Anderson's misconduct reduce that amount, and what message will this court send about landlord harassment?
The court has had an opportunity to review the videos submitted by the defendant. Is there anything that plaintiff wants to say regarding those videos?
We know nothing about the person being there. We don't recognize the person or the car.
And Ms. Lyman, how are you so sure that it was Miss Anderson there?
The guy, he was there before by himself taking pictures inside of the basement. And then
He was what?
there before taking pictures inside of the basement. And then this time,
What do you mean so I recall the issue regarding the basement. You're saying this guy entered the home.
no, he didn't come in. That's who was taking pictures outside in the window, like through the basement window.
That you had talked about before.
And then I seen her. That's why the hand was up when the car had came back past.
So your testimony is you saw Miss Anderson in the vehicle.
Yes.
On what would have been the third video that the court received.
It was the guy coming back around from the back of the house after he seen the camera.
Well, no, I think I may have received them in a different order. But the last one I had was actually, it looked like the back of the premises and there was a deck.
Yeah.
The camera, the deck I'm seeing, is that the deck that's attached to the premises you rent?
Yes.
Okay. And Ms. Anderson, you're indicating that you know nothing about that individual. Ms. Lyman, you're sure that that's the individual that was taking pictures inside the premises?
Yes.
I never.
They never
seen
came
it.
inside. They were just taking pictures from outside in the basement.
Right, right. What were you going to say, Ms. Anderson? I want to give everybody an opportunity to say what they're going to say.
I never sent anybody to take pictures of the basement. You said if you let somebody in to take pictures of the basement, I never sent
No,
anybody.
she didn't let someone in. He stood outside.
I didn't send it.
Anything else additional from either side before the court rules?
Not from plaintiff.
This exchange reveals a critical piece of evidence. Miss Lemon submitted multiple videos showing an unknown man photographing her premises through the basement windows, with what appears to be Miss Anderson waiting in a vehicle nearby. Miss Anderson denies any knowledge of this person. We're back to Michigan's implied covenant of quiet enjoyment, which exists in every residential tenancy. This covenant was established under common law and has been codified in various Michigan statutes, including MCL 554.139. The covenant of quiet enjoyment means the landlord cannot interfere with the tenant's right to peacefully possess and use the rented premises. In the landmark Michigan Supreme Court case, Resti Realty Corp. versus Cooper, decided in 1969, the court held that a landlord breaches the covenant of quiet enjoyment not only through direct interference, like harassment or illegal entry, but also through indirect interference that substantially impairs the tenant's use and enjoyment of the premises. Additionally, Michigan's trespass laws under MCL 750.552 make it a misdemeanor to willfully enter upon the premises of another without authority or permission. Even though Miss Anderson owns the property, once she's leased it to Miss Lemon, Miss Anderson must respect Miss Lemon's possessory rights. The videos create a credibility problem for Miss Anderson. Throughout these proceedings, she's maintained that she hasn't been to the property or sent anyone there, except for one drive-by. But video evidence shows a person walking around the perimeter of the property, that person photographing through basement windows, what appears to be Miss Anderson's vehicle present during this activity, the person leaving quickly after noticing security cameras. Even if we accept Miss Anderson's testimony that she doesn't know this person, the timing and circumstances are suspicious. The more natural explanation, and the one the judge will ultimately credit, is that Miss Anderson sent someone to inspect or photograph the property without giving proper notice to her tenant. This isn't the first mention of improper property access. Earlier in the proceedings, there were disputes about Miss Anderson wanting to inspect the basement and being denied access by Miss Lemon. The judge had previously noted that Miss Anderson seemed to be making pretextual excuses to access the property. Sending unauthorized persons to inspect, photograph, or otherwise interact with a rental property without the tenant's knowledge or consent is a violation of the tenant's rights. Even if a landlord has legitimate concerns about property condition, they must follow proper procedures, provide notice, schedule an inspection time, and respect the tenant's possessory interest. The cumulative effect of these incidents, the water bill takeover, the security deposit violations, the improper late fees, and now this unauthorized inspection, paints a picture of systematic harassment, which will form the basis for Ms. Lemon's counterclaim.
What I'm going to do is I'm going to render my decision, and I'm going to do it this way. The original case that was filed, which is, and let me just get it. It's 25-1C-2176. And that's the one that I'm going to render the decision on. 2176. All right. And the court has throughout this entire thing, first of all, reviewed all of the documents presented by the parties in detail. And frankly, am unsure, except as to really what is animosity between these parties as to why there is so much stuff here. And from the perspective of the plaintiff, I would just indicate that many of the allegations made by the plaintiff regarding her need to get into the premises, certain things that need to be looked at, and all of those things, quite honestly, the court views as just some pretext to interfere with the possession by Ms. Lyman. There wasn't a need. We went through, and just by way of example, we went through a whole series of hearings regarding the looking at something in the basement of something that potentially could occur that she wanted to get in the house. But Ms. Anderson was really letting her true motivations be known, because every time she would indicate that she needs to look in to make sure that the premises are in some way damaged. There was no indication whatsoever that Ms. Lyman had done that. She was then at another previous point accusing Ms. Lyman of not being the actual tenant, going so much to the extreme of asking the court to tell her to turn on the camera because that wasn't the person that she rented from and that she was dealing with somebody else. Every hearing, the person that's been appearing has been Ms. Lyman, this Ms. Lyman that I see here today. No one else has appeared. It also seems a bit disingenuous for the plaintiff to say that, because there would have been in-person contact prior to the rental in which she rented to Ms. Lyman, and the like.
The judge is beginning his final ruling, and he's not mincing words. He's found that Miss Anderson's various claims about needing to inspect the property or concerns about property damage were pretext, legal language meaning they were fake excuses designed to hide her true motivations. The judge is applying well-established legal principles about landlord conduct. In Michigan, courts have consistently held that landlords cannot use pretextual claims to harass tenants or interfere with their possessory rights. In Kiever v. Muma, a 1994 Michigan Court of Appeals decision, the court addressed a similar situation where a landlord repeatedly attempted to inspect premises under various justifications. The court held that even when a landlord has a legal right to inspect, which Ms. Anderson did under MCL 554.139, that right cannot be exercised in a harassing manner or based on pretextual claims. The court in Kiever established a test. When evaluating whether a landlord's conduct constitutes harassment, courts should consider the frequency of contact or inspection attempts, whether the stated reasons for access are legitimate, whether the landlord followed proper notice procedures, the cumulative effect of the landlord's actions on the tenant's quiet enjoyment. Additionally, the judge references something particularly egregious. Ms. Anderson at some point accused Ms. Lemon of not being the actual tenant and asked the judge to make her turn on her camera to prove her identity, despite the fact that Ms. Anderson had personally rented to Ms. Lemon and would have met her in person. Let's apply the Kiever test to Ms. Anderson's conduct. Frequency: multiple inspection attempts, sending unknown persons to the property, driving by, attempting to enter the basement on multiple occasions. Legitimacy of stated reasons. The judge found these were pretextual. Ms. Anderson claimed concern about property damage, but provided no evidence that any damage existed or that Ms. Lemon had done anything wrong. Notice procedures. The video evidence suggests inspections without proper notice. The water bill was handled without notice. Cumulative effect. Ms. Lemon is now in court defending against 2 separate lawsuits, has had her water account taken from her, has an unknown man photographing her residence, and has been accused of fraud. The judge's statement that Ms. Anderson accused Ms. Lemon of not being the actual tenant is particularly damning. This type of allegation, suggesting identity fraud or a rental scheme, is serious and could be considered defamatory if made without evidence. The fact that Ms. Anderson made this claim to a judge in proceedings about someone she personally rented to demonstrates either profound confusion or bad faith. When judges use words like pretext and disingenuous in their findings, they're making credibility determinations that will affect every aspect of the case. Once a judge determines that a party has been acting in bad faith, that party loses credibility on everything else they claim. This is why Ms. Anderson's various violations, the security deposit, the ledger, the late fees, all compound together. They create a pattern that the judge can no longer ignore.
Ms. Lyman may have had people there. She may have had other things, but Ms. Lyman has been the one here and been the one taking responsibility for that. So I don't think that Ms. Anderson, frankly, I'll just be blunt about it. I think she wants to have control of everything, including Ms. Lyman, what Ms. Lyman's doing, who Ms. Lyman has there, and the like. And none of it makes much sense to me. If she wanted to inspect for damages mid-lease, then inspect for damages mid-lease. But she came in here accusing Ms. Lyman of fraud. That has not been substantiated in any way whatsoever, that Ms. Lyman was somehow fraudulently renting the premises. It was just said that that was it, and that it wasn't Ms. Lyman. And and just over and over doing that. And I don't know why Ms. Anderson wanted to do what she was doing, but it just throughout the course of these proceedings and hearing after hearing, just this sort of berating of the tenant, saying that she wasn't doing something, just continued. While I've heard what Ms. Lyman has said and said through counsel about not knowing that person in that vehicle, I am having a very difficult time believing that to be the case, because there were people coming, testified by Ms. Lyman before, that there were people coming to the premises, all coinciding with Ms. Anderson wanting to get in. Frankly, if this were just a simple issue, and it should be, and that's how the court's going to view this case, it's a simple issue. This is a non-payment case. That's all that it is. There has been no proof whatsoever presented to the court that Ms. Lyman has damaged the premises, is causing any waste or destruction of those premises, or is in any way abusing the premises or violating any terms and conditions of her lease. But what I do think is that she's been harassed by Ms. Anderson.
The judge has made an explicit finding. Ms. Lemon has been harassed by Ms. Anderson. This isn't casual language. When a judge makes a finding of harassment in a landlord-tenant case, it has significant legal consequences. Under Michigan common law, as established in Resty Realty Corp. A Cooper and followed in numerous subsequent cases, a tenant can bring a counterclaim for harassment or interference with quiet enjoyment. When successful, such a claim can result in damages to compensate for the harassment, offset against rent owed, in extreme cases, constructive eviction, allowing the tenant to break the lease without penalty, attorney fees in some circumstances. Michigan courts use a reasonable person standard to evaluate harassment claims. The question is, Would a reasonable person in the tenant's position feel harassed, intimidated, or unable to peacefully enjoy their home? In Schultz versus Youngs, a 1996 Michigan Court of Appeals case, the court held that harassment can include frequent unannounced visits or inspection attempts, baseless accusations of lease violations, attempts to control who the tenant associates with, interference with utility services, any pattern of conduct designed to make the tenant uncomfortable or to force them to vacate. The court in Schultz also noted that the landlord's subjective intent doesn't matter as much as the objective effect on the tenant. Even if Ms. Anderson believed she had good reasons for her actions, if those actions collectively created a harassing environment, she's liable. Let's catalog what the judge identified as harassment. Repeated pretextual inspection attempts, claiming damage when none existed, false accusations of fraud, accusing Ms. Lemon of not being the real tenant, berating the tenant, repeatedly challenging her credibility without basis, unauthorized property surveillance, the videos showing unknown persons at the property, water bill interference, taking over the account and preventing the payment plan, 2 separate lawsuits, filing a second lawsuit while the first one was still impending. The judge specifically noted that this should be a simple non-payment case. The fact that it became this complicated mess is entirely due to Ms. Anderson's conduct. Ms. Lemon hasn't damaged the property, hasn't violated the lease terms, except for the non-payment, which is what they're in court to resolve, and hasn't done anything to justify the level of scrutiny and interference she's received. The judge's statement, "I think she wants to have control of everything," including Miss Lemon, what Miss Lemon's doing, who Miss Lemon has there, identifies the core problem. Miss Anderson hasn't accepted that once you lease property to someone, you don't get to control how they live their life there. You get to enforce the lease terms, period. A finding of harassment by a judge is significant for several reasons. First, it provides the legal basis for the tenant's counterclaim. Ms. Lemon can now recover damages. Second, it affects the overall judgment. The harassment damages will offset some of the rent owed. Third, it creates a record that could protect Ms. Lemon if Ms. Anderson continues this behavior. Any future harassment complaints will be viewed in light of this court finding. Most importantly, it sends a message to landlords. You can't use the threat of eviction or the power imbalance of the landlord-tenant relationship to harass tenants. Courts will protect tenants' rights to quiet enjoyment, even when the tenant owes money.
And while it may not seem much, when the water bill was coming out, and that kind of popped into this case at some point, she was even in court berating the defendant about paying the water bill. Now, certainly the water bill should be paid, and there are just different ways that landlords go about doing that. But she just continued to go after Ms. Anderson about paying the water bill. Kept saying the water bill was somewhere around $1,800. The only bill that I've received today is her $1,315. She claims that there are these other payments. I don't know that to be the case. But that's all I have in terms of the water bill is the $1,315.83. I then have, in terms of rent not paid, and I think it was explained to Ms. Lyman that the rental period starting on the 5th, but her lease doesn't end till the 4th day of the end of the term, is that 30-day or month period. So it's not like she's being shorted. She's not entitled to any type of credit for that. But as it regards the rent on the premises, there's a total amount of $19,800 owing in rent. So when I take that and the water bill together, which the water was supposed to be paid by Lyman, I come up with a total amount of $21,115 or $21,115 that is owed by Ms. Lyman. Now, I've not made any deductions for what's been paid in at this point. That would be the aggregate amount.
The judge is now calculating the actual amounts owed. He's found that Ms. Lemon owes $19,800 in unpaid rent, 6 months at $3,300, plus $1,315.83 for the water bill, totaling $21,115.83 before any deductions or credits. This calculation phase is governed by basic contract principles and Michigan's Summary Proceeding Statute, MCL 600.5714. When a court determines the amount owed in a non-payment case, it must calculate the base rent owed according to the lease terms, any additional charges the tenant is responsible for under the lease, any valid late fees or penalties, any credits owed to the tenant, escrow amounts already paid. The Michigan court rules require that any judgment in a summary proceeding must be based on competent evidence and proper calculation. In Quality Tool and Machine versus North Farms, the Court of Appeals held that trial courts have a duty to carefully review rent calculations and cannot simply accept a landlord's figures without verification. Notice what the judge did here. He didn't just accept Ms. Anderson's claim of $22,400 owed. He went through line by line. He verified the monthly rent, $3,300. He counted the unpaid months, July through December, 6 months. He calculated 6 times $3,300 equals $19,800. He examined the water bill documentation. He only credited the bill he could verify, $1,315.83, not the $1,915.80 claimed. This is exactly what Quality Tool and Machine requires, independent judicial verification of amounts claimed. The judge found a discrepancy of roughly $600 in the water bill claims and resolved it in favor of the amount he could verify through documentation. The judge also addressed Ms. Lemon's proration argument definitively, explaining that her lease structure means she's not entitled to credit for the first 5 days of May, because she'll get those days back at the end of her lease term. This demonstrates why landlords need to maintain accurate records and provide proper documentation. Ms. Anderson claimed almost $1,916 in water bills, but could only prove $1,315.83. That's a $600 difference, significant money in a case like this. If she'd maintained proper records from the beginning, she might have been able to prove the full amount.
I am concerned that there are then these additional late fees added on. And late fees should not have been charged for the defendant. Whether she paid it to the court late, there are remedies for a landlord. And let me just put it this way. That's part of the problem, is that Ms. Anderson tries to make her own rules. And she was paying escrow to the court and should not have been charged late fees. Ms. Anderson's justification, as she blurted out, as she typically does, was that she paid the rent late to the court, so therefore she's entitled to a late fee. Not the way it works. The landlord has certain remedies if she were late paid to the court, which, quite frankly, Sanderson had been able to take advantage of with the whole start of the trial in this proceeding by an immediate trial. But it doesn't give you a right to a money judgment, it gives you a right to an immediate trial. There are those things, but the late fee, not going to do it. So claiming some $900 in late fees, I'm going to take off, because that's what's been paid into escrow. So $300 comes off of that. So of late fees, there is only $600 for late fees instead of the $9 that's claimed.
The judge has just delivered a crucial ruling on late fees. Ms. Anderson cannot charge $150 per month in late fees for escrow payments that were made late to the court. He's reducing the late fee claim from $900 down to $600, a $300 reduction. This ruling is based on Michigan Court Rules 4.201, which governs rent escrow during summary proceedings. When a judge orders a tenant to pay rent into court escrow, the relationship between landlord and tenant is temporarily modified by court order. MCR 4.201D provides specific remedies when escrow isn't paid timely. The court may proceed immediately to trial. The landlord may request expedited hearing. The court may find the tenant in violation of the escrow order. The court may enter judgment based on the escrow violation. Notably absent from this list, the right to charge late fees. The reasoning is straightforward. The escrow system protects both parties during litigation. The tenant shows good faith by continuing to pay rent into court rather than to the landlord, and the landlord is protected because the money is being held securely. If the tenant pays escrow late, the remedy is judicial, not financial penalties unilaterally imposed by the landlord. In Selective Way Insurance Co. versus Piñon Cruz, the Michigan Court of Appeals addressed a similar issue, holding that once a court order governs the payment of rent, the standard lease provisions, including late fees, are superseded by the court's escrow order. The landlord's remedy for noncompliance is to return to court, not self-help through additional charges. Ms. Anderson made what the judge called a critical error. She thought she could make her own rules. When Ms. Lemon paid escrow late, Ms. Anderson decided, I'll just charge late fees like I would for regular rent. But here's the problem with that logic. Ms. Lemon wasn't paying rent to Ms. Anderson. She was paying it to the court. A court order was in place governing how payments were to be made. Ms. Anderson's remedy was to notify the court, not charge penalties. By adding unauthorized late fees, Ms. Anderson was essentially finding Ms. Lemon in contempt of court, something only a judge can do. The judge specifically notes that Ms. Anderson has been able to take advantage of expedited proceedings because of late escrow payments, meaning she did receive a remedy, faster resolution of her case. She can't have it both ways, getting expedited trial and imposing financial penalties. The judge reduces the late fee claim by $300, representing 2 months of the $150 monthly late fee for the 2 months paid into escrow. This means Ms. Anderson can claim late fees for months before escrow was ordered, but not for the escrow period itself. This ruling establishes an important principle. Landlords cannot circumvent court orders by imposing their own penalties. When a case is in litigation and the court has issued orders, those orders control. This is why landlords need legal counsel who understand court procedure, not just lease enforcement. The judge's comment that Ms. Anderson tries to make her own rules will echo throughout the rest of the decision. It's a devastating credibility finding that characterizes her entire approach to this landlord-tenant relationship.
Now, the other problem that I have is that I don't know where Ms. Lemon's security deposit is. I can't get a straight answer. What I know is it apparently is commingled with the funds of the plaintiff. It's absolutely inappropriate under our statutes and should be held in a separate account for which Ms. Lyman, because it was really her money that the landlord is holding, has to be notified as to where it is, the financial institution and the like. That is a clear violation of the law in the way that Ms. Anderson is conducting her business. I also don't know that her counting is all correct, because there were certain numbers that had to come off and come on, and somehow the notice that was sent on this case would have been incorrect. The notice that was sent to the tenant regarding the amount she owed would have been incorrect, because there was at least the $100 credit, and then presumably other credits that went to the tenant. Credits of, and I say it this way because it's money that she's paid. It doesn't necessarily change the bottom line, but it's certainly money that she's paid. And Ms. Anderson knew or should know that she's received the funds from Ms. Lyman. But somehow or another, Ms. Lyman has to get herself here to explain to the court that I made these payments. There isn't a ledger in the sense of a ledger of her payments each month, because apparently Ms. Anderson believes she didn't have to keep a ledger, an account ledger, until the time that she filed the notice, or until, actually what she said is until she paid into escrow. I don't even know where that comes from. That doesn't even make any sense. And certainly it's not a sound business practice by any stretch of the imagination.
The judge has found multiple violations related to how Ms. Anderson handled the security deposit and record keeping. He's particularly troubled by the commingling of funds and the absence of a complete ledger from the beginning of the tenancy. Let's review the specific violations the judge identified matched with the statutes. Violation 1. Commingling funds. MCL 554-608-1 explicitly states, a security deposit shall be deposited in a regulated financial institution, and the landlord shall not commingle the deposits with their personal assets. This is a strict liability violation, meaning there's no excuse. It doesn't matter if Miss Anderson meant to keep it separate or if she mentally tracked which money was whose. The law requires physical segregation in a separate account. Violation 2. Failure to notify of account location. MCL 554-608-2 requires, within 30 days after receiving a security deposit, the landlord shall notify the tenant in writing of the financial institution and address where the deposit will be held. Miss Anderson admitted she never notified Miss Lemon when she moved the deposit from Chase to Lake Michigan Credit Union. Violation 3. No proper record keeping. While Michigan doesn't have a specific statute requiring landlords to maintain ledgers, the Michigan Court of Appeals has held in multiple cases, including Keever versus Muma, that landlords have a common law duty to maintain accurate records of all financial transactions with tenants. The judge's statement that Miss Anderson believed she didn't have to keep a ledger until she filed a notice reveals a fundamental misunderstanding of business and legal obligations. This isn't just poor practice, it makes it impossible to verify what was paid, when, and what credits or charges were applied. The consequences of these violations are severe. Legal penalties. Under MCL 554-608-7, a tenant can sue to recover their full security deposit plus damages if the landlord violates the statute. The judge could have awarded Miss Lemon her entire deposit back as a penalty. Evidentiary problems. Without proper records, Miss Anderson couldn't prove her claims. The judge had to reconstruct payments from Miss Lemon's bank records and testimony. This put Miss Anderson at a disadvantage in her own case. Credibility damage. The judge uses phrases like, "I can't get a straight answer," and "doesn't even make any sense." Once you've lost credibility with a judge on financial matters, everything else you claim becomes suspect. Notice defects. The judge notes that the notice Miss Anderson sent to Miss Lemon demanding payment was incorrect because it didn't account for credits owed. Under MCL 600.5716, a defective notice can invalidate summary proceedings. The judge's observation that Miss Lemon has to get herself here to explain to the court that I made these payments highlights the absurdity. The tenant shouldn't have to prove she paid rent. The landlord should have records showing every payment received. Professional landlords understand that being a landlord is running a business, and businesses must keep accurate financial records. It's not just good practice, it's legally required. When you fail to do so, you lose credibility, weaken your legal position, and may face statutory penalties. This case should serve as a warning. If you're going to be a landlord, either maintain proper records yourself or hire a property management company to do it. The alternative is exactly what we're seeing here, a case where the landlord's claims are being systematically reduced because she can't prove them.
I think Miss Anderson was trying to harass Miss Lyman. I've said it in the regard to how she handled her tenancy, but I also think, and this was not certainly counsel's doing, but there's a case that was pending before the court that the court was coming back to render a decision on. And for some inexplicable reason, Miss Anderson files a new case that then gets served on Miss Lyman as, frankly, as the court interprets it, is just an added attempt to try to pressure Miss Lyman to pay. The court never got a straight answer as to why this was even filed. But I just find it odd because also, and falsely, at least based upon what's been claimed here, in that complaint, she alleged $1,500 water bill, which supposedly was due October 6th. Now, I've never seen a rounded off water bill. I'm sure it exists someplace, but I've never seen one like that. And that's what she put on there. And again, I think it was just an attempt to try to pressure Miss Lyman into doing something that maybe she was entitled to. But again, I could never get a straight answer as to why this next case was even filed. It made no sense to me whatsoever. This action was already pending, and it just made no sense whatsoever from the court standpoint that it was filed.
The judge has identified that Ms. Anderson filed a second eviction lawsuit against Ms. Lemon while the first case was still pending and awaiting the judge's decision. He views this as harassment and an improper attempt to pressure the tenant. Filing multiple lawsuits for the same claim is generally prohibited under several legal doctrines. Res judicata. This Latin phrase means the matter has been judged. Under Michigan law, once a case has been filed and is pending, you cannot file a second case involving the same parties and the same claims. To do so is an abuse of process. MCR 2.116C7 Michigan court rules provide that a defendant can move to dismiss a case when another action has been initiated between the same parties involving the same claim. This prevents duplicative litigation. Abuse of process. In Smith versus Anonymous Joint Enterprise, the Michigan Court of Appeals held that using legal process for an ulterior purpose, such as harass, intimidate, or coerce, can constitute the tort of abuse of process, for which the victim can sue for damages. Additionally, MCR 1.109 authorizes courts to impose sanctions on parties or attorneys who file frivolous claims or engage in conduct meant to harass or needlessly increase litigation costs. Let's examine what happened here. Ms. Anderson filed case number 1, which went through multiple hearings. The judge heard evidence, reviewed documents, and took the matter under advisement to issue a ruling. While Ms. Lemon was waiting for that decision, which could take days or weeks, Ms. Anderson filed case number 2. The second complaint contained several red flags the judge identified. It claimed a rounded water bill of exactly $1,500, suspicious because utility bills are calculated to the penny. It was allegedly due on October 6th, but we've heard the actual bill was $1,315.83. No explanation was given for why a second case was necessary when case number 1 was still active. From Ms. Lemon's perspective, imagine, you're already defending one eviction case, you've appeared in court multiple times, you're waiting for the judge's decision, and suddenly you're served with a second eviction lawsuit. You now have 2 pending eviction cases, 2 sets of court dates, 2 potential judgments against you. This is exactly the type of pressure tactic the judge identified. Ms. Anderson was essentially saying, I don't care if the judge hasn't ruled on case number 1, I'm going to keep piling on lawsuits until you pay me. Courts take abuse of process seriously because it undermines the integrity of the judicial system. When parties file multiple lawsuits for the same claims, it wastes judicial resources, harasses the defendant, clogs court dockets with duplicative cases, creates conflicting potential judgments, amounts to legal bullying. The judge's finding that this was done to pressure Ms. Lemon is significant. It transforms what might be seen as mere procedural error into intentional misconduct. This finding will support Ms. Lemon's counterclaim for harassment and will influence the judge's final calculation of damages. The judge also notes this was not certainly counsel's doing, a subtle way of saying Attorney Mall likely advised against this, but Ms. Anderson insisted. This is why landlords need to listen to their attorneys, not just hire them as mouthpieces for their own questionable strategies.
Because of all of the harassment, I think intentional interference with Miss Lyman's quiet and peaceful enjoyment of the premises, what the court is going to do is the court is going to award on her counterclaim on that $1,700 to her. That would bring the plaintiff's judgment to a total amount of $20,015 plus the $183.59. And counsel, I just want to make sure, which case are you getting your costs from? Because is that the new filing or the old filing fee?
We became involved in this case. I mean, in his proceedings after the second case was filed.
Correct. So that I just want to make sure those are the costs you're giving me is from the second.
Well, no, actually, her figure is the cost come from the first case. Is that right?
I was combining.
She was combining them.
Pardon?
She was combining the two cases.
It was the first case. I don't know.
Oh, you don't know. Well, we'll just take the filing fee and the service fee and filing fee was what, 7,500?
Well, here's the problem. On the first case, I have a filing fee of 130 and a 55 filing fee on the second case. I have a service fee on the first case of 32.30, as well as 32.30 and 32.20, respectively, between the cases.
32.30, 32.30 and 32.20?
So, yeah, so here's what I'm going to do. The only cost I'm going to award, counsel, is I'm just going to award the lower of them. And so I'm just going to award 87.20 in cost.
Okay.
Because and again, it's on a case that should have never been filed, but that's the way I'm going to do that. And that would make the total judgment to the plaintiff. If they have me do math here, but 0, 1. I get $20,102.20 is the total judgment. And this is why I am going. $20,120
At $20.
or 20102.20.
All right. Okay.
And then Ms. Lyman has posted into escrow, subtract off of this $8,870.
May I ask, has the court determined that that's the correct figure? Because it was 60 when I came in this morning.
There were 66, and then there was another. I had determined that there was
Okay.
2,000. Yeah, posted.
Okay.
Ms. Lyman, you have your hand raised.
Yeah, because that doesn't seem right to me. If I only owe the last 3 months, that's $9,900. With the water bill, that should only be $11,000. And then
11,000. Correct. You know what? I know part of what. So here's what I did. I'm only going to. So the total figure that I came through with rent, water, and late that we just went through is $21,015. Okay. I'm awarding them cost of, let's say,
87.20.
$87.20. Would then bring the total amount of their judgment amount up to $21,802.20.
so even in the prior proceeding, when she said she wasn't counting,
I only gave for 4 of those months.
you know, that she had said before.
I understand what she said, but under the lease, she's entitled to.
Even if she said it, or even if it's on recording that she said it.
So how many times do you think you're going to answer the question and get a different answer from me? Well, I think I'm pretty clear in what I said. And then I'm going to subtract out from that figure the $8,870.
Which is you 12,920,
12,920.
32.
So after the escrow is released to the plaintiff, that would lead to a judgment of $12,932.20.
The judge has awarded Miss Lemon $1,700 on her counterclaim for harassment and interference with quiet enjoyment. This substantially reduces the final judgment against her. Counterclaims for interference with quiet enjoyment are recognized under Michigan common law. The covenant of quiet enjoyment is implied in every residential lease, meaning it exists even if the lease doesn't explicitly mention it. In Wade v. Job, a 1993 Michigan Court of Appeals case, the court explained that damages for interference with quiet enjoyment should compensate the tenant for mental distress and emotional harm, inconvenience and disruption, loss of use and enjoyment of the premises, costs associated with the landlord's harassment, such as time off work for court appearances. The court in Wade also held that these damages can be used to offset rent owed, creating a net judgment that accounts for both parties' claims. Additionally, in Hilson-Deggen versus Scheich, the Michigan Court of Appeals noted that determining the amount of damages for quiet enjoyment interference is within the trial court's discretion based on the totality of circumstances and the severity of the harassment. The judge awarded $1,700, which he specifically notes is historically a large amount for that type of claim from this court. This tells us the harassment was significant. Let's trace what the $1,700 compensates Ms. Lemon for. Multiple court appearances, time and stress, unauthorized inspections and photography of her home, being accused of fraud and identity deception, having her water service taken over without permission, being subjected to 2 separate eviction lawsuits, the general stress of feeling monitored and harassed in her home. The judge then performs the calculation. Total owed before counterclaim is $21,115.83, rent plus water, minus late fees improperly charged, minus $300, minus harassment damages, minus $1,700, plus reduced court costs, plus $87.20, equals gross judgment $20,015, approximately. The judge rounds slightly. Minus escrow already paid, minus $8,870. Final judgment, $12,332.20. Effectively, Ms. Lemon went from owing over $22,000 as originally claimed down to $12,332.20, a reduction of almost $10,000. This dramatic reduction demonstrates the real-world consequences of landlord misconduct. This ruling sends several important messages. Harassment has a cost. Landlords who mistreat tenants will pay for it, literally. The $1,700 award reduces the amount Ms. Anderson recovers. Judges have equitable power. Even in a simple non-payment case, judges can and will consider the landlord's conduct and adjust the judgment accordingly. Multiple violations compound. It wasn't just one thing. It was the security deposit, the late fees, the water bill, the inspections, the second lawsuit. Together, they justified a substantial award. Tenants have rights. Even when you owe rent, you still have rights. A tenant in breach of the lease still deserves to be treated lawfully and with basic dignity. For landlords watching this case, the lesson is clear. Even if you're owed $19,800 in rent, if you violate your tenant's rights in collecting it, you might end up with only $12,332.20 after the court accounts for your misconduct.
The order of eviction date on this matter will be January 5th, 2026. So that amount would need to be paid by that date. Now, so that, and I'm going to say this directly to you, Ms. Anderson, the monies that come in must be applied to the judgment. So if she paid $3,300 and the judgment is still outstanding, apply to the judgment. You can't just say I've taken it as January and she still owes me this. It may be that if she gets that money all by that amount paid and it hasn't paid January rent at that moment, you're going to have to start over on another case. Am I clear on that? Am I clear on it? This is just simple math. Any monies that come in must be applied to the judgment. Don't come back in here having accepted $3,300 saying you're applying it elsewhere.
The judge has set an eviction date of January 10th, 2026 and given explicit instructions about how any payments from Ms. Lemon must be applied. He's warning Ms. Anderson not to manipulate payment applications. This instruction addresses a common problem in landlord-tenant law, how payments are applied when there are multiple debts or obligations. Under Michigan common law, generally the debtor, Ms. Lemon, has the right to designate how her payments should be applied. However, when there's a court judgment, MCL 600.6201 et sec, Michigan's judgment enforcement statutes, provide that payments must first be applied to satisfy the judgment before they can be applied to new debts. In Stout v. Stokes, a 2002 Michigan Court of Appeals case, the court held that a creditor, landlord, cannot circumvent a judgment by claiming that payments are being applied to new obligations rather than the judgment debt. The court reasoned that allowing this would enable creditors to perpetually keep debtors in default while accepting their money. Additionally, MCR 2.614A requires that judgments be satisfied in full before additional claims can be pursued for the same type of obligation, like monthly rent. The judge is anticipating a problem. January rent will come due before the January 10th eviction date. If Ms. Lemon pays $3,300 in early January, Ms. Anderson might be tempted to say, "This $3,300 is for January rent. You still owe me the $12,332.20 judgment, so I'm going forward with eviction." The judge is explicitly prohibiting this. Here's the correct application. First dollar Miss Lemon pays applied to the $12,332.20 judgment. Every subsequent dollar applied to the judgment until it's paid in full. Only after the judgment is satisfied can new monthly rent obligations accrue. So if Miss Lemon pays $3,300 in early January, the $3,300 reduces the judgment from $12,332.20 to $9,032.20. January rent might technically be due, but Miss Anderson can't evict on the January rent until this judgment is paid off. To pursue the January rent, Ms. Anderson would need to file a new case after this judgment is satisfied. The judge uses the phrase simple math somewhat sarcastically. He's seen Ms. Anderson's creative accounting throughout this case and wants to make absolutely clear that there's no room for manipulation here. This type of explicit instruction is unusual and reflects the judge's lack of confidence in Ms. Anderson's willingness to follow standard procedures without court supervision. This instruction protects Ms. Lemon from a common landlord tactic, accepting payments but claiming they don't count toward the judgment. Some unscrupulous landlords will accept rent checks, claim they're for the current month, and then proceed with eviction for the judgment debt, essentially double dipping. The judge's warning, "Don't come back in here having accepted $3,300 saying you're applying it elsewhere," is remarkably direct. He's essentially saying, "I've seen your conduct throughout this case, and I'm not going to let you continue to manipulate the situation." This type of explicit instruction is unusual and reflects the judge's lack of confidence in Ms. Anderson's willingness to follow standard procedures without court supervision. This case provides crucial lessons for anyone involved in residential real estate, whether as a landlord, tenant, or property manager. Let's break down the key takeaways. Maintain proper records from day one. Ms. Anderson's failure to keep a complete ledger from the beginning of the tenancy cost her dearly. The judge couldn't verify her claims, found discrepancies in her accounting, and ultimately reduced her recovery by nearly $10,000. Under Michigan law, particularly MCL 554.608 regarding security deposits and the common law duty to maintain accurate records established in Kieber versus Muma, landlords must keep detailed, contemporaneous records of all rent payments received, dates and amounts of payments, security deposit location and amount, all charges, fees, and credits, utility payments if landlord paid, inspection reports, and correspondence. This isn't optional. It's your proof when you need to enforce the lease or defend against counterclaims. Security deposits must be properly segregated. The commingling of security deposits is a strict liability violation under MCL 554.608(1). It doesn't matter if you mentally track which money is whose, the statute requires physical segregation in a separate account at a regulated financial institution. Additionally, MCL 554.608(2) and 4 require written notice to tenants of where the deposit is held, the financial institution name and address, the account number, any change in where the deposit is held. Violating these requirements can result in forfeiting the entire security deposit plus damages. Don't file multiple lawsuits for the same claim. Filing a second eviction case while the first is pending is improper under Michigan court rules and can constitute abusive process. It wastes judicial resources, harasses the tenant, and will undermine your credibility with the court. This case from Michigan's District Court demonstrates how vital it is for landlords to understand not just their rights under the lease, but their obligations under state law and court rules. The covenant of quiet enjoyment, security deposit statutes, proper record-keeping requirements, and restrictions on landlord self-help aren't mere technicalities. They're fundamental protections that courts will enforce rigorously, even when the tenant owes significant back rent. For tenants, this case shows that even when you're behind on rent and facing eviction, you still have rights. Landlords who violate those rights can face counterclaims that substantially reduce their recovery. Document everything, know your rights, and don't be afraid to assert them in court. For landlords, the message is equally clear. Being professional, maintaining proper records, following statutory requirements, and treating tenants with respect isn't just good ethics, it's good business. The costs of cutting corners, as Ms. Anderson learned, far exceed the costs of doing things right in the first place. Let us know if there's a case or courtroom interaction that you'd like us to cover in the comments below. Landlord-tenant disputes, criminal proceedings, civil litigation. We're here to help break down the law and make it accessible to everyone. Thank you for watching, and don't forget to subscribe and share so that we can help foster a more informed society. Understanding your rights, whether as a landlord, tenant, or any other party in our legal system, is the first step toward protecting those rights effectively.